A very pleasant good afternoon, ladies and gentlemen. Welcome once again to the People's Forum of In the Streets with Big Stone. As you know by now, the case of the 7-year-old little girl has gone viral. People from all over the world are viewing and making their comments and talking about it, and some are even very angry. There are reports in the news that some threat was actually made to the Supreme Court judges who looked over the case. And I'm going to take a look at some of the reasons why the court ruled in favor of the little girl not going back into school. And then I'll give you my summary at the end of this reading. So let's take a listen. Court outlines ruling in dreadlocked student case. Attorney showed clear misunderstanding of the law on freedom of religion, says the judge. The no braids, no beads, no locks policy of Kensington Primary School did not violate the constitutional right of the 7-year-old daughter of Cheyenne and Dale Virgo. A full court panel of Supreme Court judges stated in a written statement released yesterday. At the same time, the judges said attorney at law Isaac Buchanan, who represented the family, showed a clear misunderstanding of the law in his submission on the issue of freedom of religion. While I'm in agreement that people have a right to express their religious beliefs, or indeed in any other conscientiously held beliefs to which they adhere, there is nothing in this case that directs the mind of this court to believe that the claimant's right to freedom of religion has been breached, as she has not adduced sufficient evidence to this court to say that the action of the school infringed this right. For example, by somehow encouraging or forcing the child or parents away from their stated beliefs. Beliefs which I might add were never disclosed, Justice Sonia Bertram Linton said. Mr. Buchanan violently tried to convince the court that all persons who wear locks are to be automatically identified as Rastafarian, and as such do not have to state their religious beliefs. I cannot support this submission, the judge stated. The written judgment, which followed a ruling added down last Friday by Justice Bertram Linton, Evan Brown, and Nicole Simmons, also said that a decision as to a choice of personal expression taken by a child and their family cannot be imposed on a school in contravention of a school rule or policy. The judges made it clear that the case was in no way about Rastafarians being prevented from having their children attend a public institution because of dreadlocks worn out of religious observance. That issue has long been settled in our school system, and there are countless children throughout our schools in attendance who wear dreadlocks, Justice Bertram Linton stated in the 60-page judgment. Highlighting the admission of the claimant's attorney that the religious belief of the parents were never communicated to the school, Justice Bertram Linton said the attorney's argument that the parents or the child did not and should not have to disclose any religious adherence, and that the child should be allowed to attend school in the way that her hair was adorned because it represented the family's decision, was a bold and generalized statement which, if taken at face value, has innumerable implications for the length and breadth of self-expression that should be allowed in our schools. There is no dispute that the school established this policy not as a way to maintain discipline and order in the school, but as a preventative measures in the case of an outbreak of lice or ginger. It is clear from the evidence that the school had sanctioned this policy on the basis of its own experiences with unhygienic students in the past, she said. Having regard to the assessment of the authorities, I am of the view that the facts of this case do not support a finding that the right to equality before the law has been engaged, let alone infringed by the defendants. The policy in question does not meet the criteria, it not being a law, she stated further. In the meantime, she said, there was not sufficient evidence presented to the court that the school had infringed the right of the minor in question by enacting a policy that interferes with the protection afforded to her as a child. It is not sufficient, in my view, to base my decision solely on the reaction of the mother, particularly when she had not acted upon the suggestion to cut her daughter's hair. I have to keep in mind that this case is about the right of the child and not that of the mother. It is my view that there was no justifiable physical or mental harm which would have been caused by the defendants. The withdrawal of the space at the school never materialized. The act of removing the locks of the child's hair could have only been carried out with the knowledge and consent of her parents, the judge said. Furthermore, what is discernible from this interaction is that the claimant's mother/parents throughout this interaction did not inform the school that their daughter had locked hair for religious purpose, and it is evident that the hairstyle the child was wearing was not easily identified as such. The view is supported by the information in the affidavit of Christine Hamilton, the current principal. She said that during orientation, the child hairstyle was identified as sister locks and that the mother had indicated that the hair was just a style, the judge pointed out. I find that the policy of the school did not breach a child's right to education. The child does not have a right to attend a particular institution, and as such, Kensington Primary School can reject the child as a student. This does not affect her right to education, as she could always attend another school that supports her form of expression. Furthermore, the judge said they had failed to establish how the minor has been treated differently than any other child in similar circumstances to her own, and therefore the court was not of the view that her right to equitable and humane treatment had been infringed by the school. Addressing the argument that in the current cultural context, as black people and Jamaicans, the lock hairstyle should not have to be explained and justified, Justice Bertram Linston said, in my view, schools cannot survive or be run without rules for the various constituents that make up the school population. So I don't know if you understand what is going on, ladies and gentlemen, because the law has certain way of putting certain particular words, and the law has a way of phrasing or using certain terminology that maybe even the lawyer that was actually looking at this case didn't even understand, because what the judges are saying that the lawyer misunderstood what it means to religious practices as well as just an hairstyle. I don't know if this is true because this is coming from the newspaper, so I can't say the mother said that, but it is because of the statement that what is written here. The mother is saying that when the school asked her about this particular hairstyle, she said it was just a style, and she did not explain the reasons as to why the locks itself was worn. I think if it was carried across to the school that, hey, my child hair is worn like that because I am a Rastafarian, this is our religion, and this is what we practice at home with our children, our religion, then it would have been a different outcome. As to the threat and so on of the Supreme Court, I do not agree with that. We cannot threaten the courts of our system. But what we can do is we can group up, we can protest, we can make sure our numbers are felt, because remember, in anything, numbers count. If a politician is looking at 500 people gathered at a particular place to hear their growls about a particular case, you can best believe that politician is going to take a deeper look. If 2,000 or 5,000 people show up at a particular place or a venue in protest of this law, you can best believe the government is going to take a different look at the law, because numbers are very important. We're coming on to an election, and can you imagine if 2,000 or 3,000 or 5,000 or 10,000 Rastafarian gathered in their numbers in front of the Prime Minister's office or the court downtown? Can you imagine the outcome? The outcome would have to be, they will have to reverse that decision. So I'm not with you trying to arm any judge or anything like that. It doesn't get us anywhere. But guess what? Our actions, our togetherness, our unification, our act of protesting, that is the only way we can win this. Alright? The ballot is mightier than the bullet. Thank you very much for watching. Please like, share and comment on this video. And if you have not yet subscribed to my channel, please do. Thank you so much for watching and have a great day.